Usually when we talk about a medical diagnosis, there's this underlying expectation of precision. Like it feels almost like engineering.
Right, it's incredibly binary.
Yeah, you fall off your bike, your arm hurts, you go to the hospital. The doctor puts you in that machine, takes the x-ray, pulls up the image, and well, there's that jagged white line on the screen.
And they just point to it and say, there it is, that's the fracture.
Exactly. The doctor points and you have your answer. And honestly, I think human beings crave that. We like things to be visible, to be categorized neatly into broken or not broken.
Oh, completely. It gives us a really clear path forward. It's comforting.
It is comforting. But then you step out of the hospital and into the world of governmental power and the administrative state and legal authority, and suddenly that x-ray machine is it's totally malfunctioning.
It is the definition of diagnostic muddy waters.
It really is. We're looking at a landscape that is, honestly, terrifyingly murky. Because think about it. When a government official sends you a letter or knocks on your door or a new agency mandate drops telling you that you have to completely change how you run your business, how do you actually know if it's a lawful command?
Right. Or if it's just, an exercise of brute force.
Yes. You've hit on the absolute core anxiety of modern civic life. Most people they don't know.
They really don't. They feel this sense of unease, maybe a feeling that something isn't quite right, but they lack the x-ray machine to pinpoint exactly where the fracture in the government's authority actually is.
Which is exactly why we are pulling out a completely different kind of diagnostic tool for today's deep dive. We are looking at a text that acts like, almost like a high-resolution MRI for governmental action.
And it is a fascinating one.
It's called the Firewall Standard, 12 Controlling Principles for Testing the Lawfulness of Governmental Action by Publius Custos. We're looking at the revised edition from July 2026.
Yeah, and what's so wild about this text is that it strips away all of our usual talking points.
Oh, completely. Usually when people argue about a new law or an executive order, what are they arguing about? They're arguing about whether it's a quote-unquote good idea or if it's compassionate or cost-effective.
Right, they argue about the outcome. They treat politics like a debate over customer service. Like, is this policy going to make my life better or worse?
Exactly. But the Firewall Standard doesn't care about the policy outcome. It doesn't care about the political party proposing it. It demands that we look at the raw mechanics of power.
It forces us to ask the prior ultimate question, which is simply, but what lawful authority may this act be done?
And the text introduces a core distinction right out of the gate that, honestly, it completely rewired how I look at the news. It's a phrase that has been bouncing around in my head for days.
Which one?
Enforcement proves power. It does not prove law.
Oh, yeah. That is the thesis statement of the entire framework.
It's so profound. Because just think about a mugger in an alley. A guy steps out with a weapon and says, "Give me your wallet." He possesses the practical force to compel your obedience, right?
Right. He can enforce his will.
But no one in their right mind would say he has the legal authority to take your property. Yet when the government does it, we get so confused.
We really do. We think that because an institution can put you in a cage or freeze your bank account or levy a massive fine, that they inherently must have the legal right to do so.
That's the psychological trap, isn't it? We tend to look at the trappings of power: a shiny badge, a judge's oak-paneled courtroom, a regulatory seal on a piece of letterhead.
Or even a bill passed by a legislature.
Exactly. And we automatically presume, well, they are the government. They wouldn't be doing this if they weren't allowed to.
We treat the government as if it's self-validating. But this standard argues that those symbols merely prove that power is being exercised in a specific moment.
They don't prove the chain of lawful authority.
No, they don't. Under this framework, the government actually bears the burden of proving its own jurisdiction every single time it acts.
Okay, I want to really dig into this because to understand how a government can act lawfully, the text insists that we have to rewind the clock. We have to understand what existed before the government was ever created.
And this takes us into the foundation of the whole system. The text lays out this incredibly strict sequence of existence.
Right, and it goes law, then rights, then the people, then the Constitution, and finally government.
Yeah, that sequence is vital.
When I first read that, my brain sort of short-circuited a little bit. Because how can law and rights exist before the government? Doesn't the government make the laws?
If we look at how the modern mind is trained, that confusion is completely understandable. We're taught that law is just, whatever the legislature votes on a Tuesday.
Right, exactly.
But the Firewall Standard reaches back to a much older structural understanding of jurisprudence. In this sequence, government is at the very end of the line. It is a derivative creation. It's a tool.
So it's not the source.
Exactly. Government is subject to law. It's not the source of it. Any act that assumes the government creates law merely by commanding it or enacting it or enforcing it is classified under this standard as fiat, not law.
Fiat. Just pure arbitrary will, like a parent saying, because I said so.
Precisely that. The standard argues that government cannot create the law that creates government. It's a logical impossibility.
Oh, wow. Yeah, that makes sense.
Think about it. An agent cannot create the authority that authorizes the agent. You can't hire yourself to do a job you haven't been given by the person who owns the company.
Right. So the legal order has to begin before the state.
Yes.
Yeah.
In this framework, law isn't a statute. Law is an antecedent rule of right that protects what is rightfully possessed by a human being, which leads directly to the second principle: rights are pre-political.
Pre-political, meaning they exist independently of any governmental grant.
Exactly.
So the government doesn't hand out rights like they're Halloween candy. It doesn't give you freedom of speech or the right to defend your life.
No, it is instituted to secure boundaries that were already there. That's the critical paradigm shift here.
It really is.
A governmental act that treats an antecedent right as a privilege or a benefit or a permission slip actually reverses the entire constitutional order.
Think about how often people talk about their constitutional rights as if the piece of paper gave them the right.
Right. But the standard says, no, the paper doesn't give you anything. The paper is just a fence brinked around what you already owned by virtue of existing.
Wow. So if you have to ask the government for a license to exercise ordinary, peaceful liberty,
then the government is treating your inherent right as if it were governmental property that they are generously leasing back to you.
All right, let me try an analogy here to see if I'm tracking the mechanics of this.
Yeah.
Imagine you buy a piece of land and you build a house on it.
Okay, I like where this is going.
So the land represents your rights and the antecedent law. That land was there long before the house was ever built. And the house is the government. We, the people, built the house on top of the land to keep the rain off, to secure the property from wolves, to have a structure. But the house doesn't own the land.
Exactly.
The walls and the roof don't get to look down at the dirt and say, I am the source of this dirt. I grant you permission to be soil.
That is a phenomenal way to visualize it. The house is an instrument. It serves a specific protective function for the land, but it is subordinate to the land.
But here's where it gets complicated. Because we live in a society where people claim they have a quote-unquote right to almost everything.
Oh, absolutely.
A right to housing, a right to the internet, a right to a certain minimum wage. Because the land was there first, we need a way to figure out what actually belongs to the land and what is just a feature or a service that the house provides.
And this is where the Firewall Standard introduces what it calls the pocket test.
Yes. This was a massive aha moment for me. Walk us through how this pocket test actually works in practice.
Well, the pocket test is one of the most ruthless diagnostic tools in the entire text. It's designed to cut through the rhetoric of political campaigns and figure out if something is a genuine, pre-political right or if it's something else like a statutory benefit.
So what's the actual test?
It asks a very simple mechanical question. Whose person, whose labor, or whose property must be non-consensually taken to satisfy the claim?
Okay, let's apply this. Give me a concrete example.
Let's take the right to free speech. If you claim a right to speak your mind in the public square, does satisfying that right require the government to reach into someone else's pocket and take their money?
No.
Does it require the government to force someone else to build you a printing press?
Obviously not, no.
No. It simply requires that others refrain from attacking you or silencing you. It's a negative restraint against invasion.
Right. It's just me standing on my land, opening my mouth. I'm not taking anything from anyone else.
Exactly.
Right.
Now, compare that to a claimed right to health care or a right to high-speed internet. For the government to satisfy that claim, what must it do?
It has to get those things from somewhere.
Right. It cannot conjure doctors, nurses, medicine, or fiber optic cables out of thin air. It must forcibly take the labor of the medical professionals, or must reach into the pockets of the taxpayers to fund the infrastructure.
It has to cross a boundary. It has to take from Peter to give to Paul.
That is the friction point. The standard doesn't say that public health care or public infrastructure are evil. It simply classifies them accurately.
Right, because words mean things.
Exactly. If a claim requires the non-consensual taking of another's labor or property, it is not a pre-political right. It might be a valid statutory benefit. It might be a public service that the community voted to fund. But it is structurally different from a fundamental right.
Because a fundamental right operates as a restraint against invasion. It doesn't compel someone else to provide you with a good or service.
You've got it. If you blur that line, you end up with a house that thinks it has unlimited authority to redistribute the soil of the land however it sees fit.
I see, that clarifies so much. But wait, I have to play devil's advocate here for a second.
Go for it.
If a right is unalienable and it exists before the government, doesn't that mean I can just do whatever I want? Like, if my liberty is pre-political, where is the line?
That's a great question.
Let's say I want to blast heavy metal music from giant speakers in my backyard at 3 a.m. on a Tuesday. Isn't that my unalienable liberty to use my property how I see fit? Why can the House tell me to turn it down?
This is a crucial area of misunderstanding, and the text addresses it head-on with what it calls the equal boundary rule, which is Rule 2.11.
The equal boundary rule? Okay.
Yeah, the standard explicitly rejects the idea that unalienable means unregulated or without boundaries. The text defines a right not as a limitless void of personal desire, but as a defined sphere of lawful possession.
So it's boxed in.
Right. And your protected sphere ends exactly where the corresponding boundary of every other person's equal right begins.
So my right to swing my fist ends where your nose begins.
Exactly. Liberty does not include the lawful authority to injure someone else. Property does not include lawful title to stolen property. Self-defense does not authorize unprovoked aggression.
So, in my heavy metal example...
In your heavy metal example, your right to enjoy your property is colliding with your neighbor's equal right to the peaceful enjoyment of their property. The sound waves are physically invading their space and causing an injury to their peace.
So the boundary is real, the law is the fence between the properties.
Yes. And when there is a dispute at the fence line, the government's job is to adjudicate that conflict according to the pre-existing law. It looks at the boundary.
It just reads the fence line.
Right. But here is the critical limitation. The government cannot resolve the conflict by just arbitrarily declaring that only one side possesses rights or by erasing the boundary altogether.
It can't just pick a favorite.
No, it cannot say, we prefer heavy metal music, so we are eliminating the neighbor's property rights. It must judge the specific invasion.
Which brings up another fascinating textual test from the standard, the delegation versus exception test. Because a lot of this comes down to how we actually read the founding documents and the constitutions that built the House in the first place.
This part is so vital for anyone trying to interpret legal authority. The standard requires us to examine the actual operation of the words in a constitution, not just the title of the clause.
What do you mean by the actual operation?
Well, sometimes the Constitution will say, the right of the people to keep and bear arms shall not be infringed, or it will say, Congress shall make no law.
Okay, yeah.
These are true rights reservations. They are exceptions out of the general powers of government. They clearly mark the boundary of the land that the House is explicitly forbidden from building on.
They are do not enter signs.
Exactly. But what if the text says something like, the people shall have a right to hunt, subject to such conditions as the legislature may prescribe?
Oh, well, that completely changes the game. If it's subject to what the legislature prescribes, then the legislature is the one holding the cards.
Precisely. Under the standard, that is not a pre-political right. That phrase, subject to conditions, operates as a delegation of power to the government to control, define, or limit the subject.
Wow. You cannot treat a delegation of power to the government as if it were a reservation of rights for the people.
No, you can't. The standard forces us to classify the legal interest accurately. Is it a pre-political right, or is it a statutory privilege? Is it a public benefit, or is it a license?
Because if you mix them up...
Because if you misclassify a delegated power as a fundamental right, or vice versa, the entire diagnostic chain breaks down. You give the X-ray machine faulty data.
Okay, so we've established the foundation. Law and rights are the land. They were there first. They have strict boundaries. The House cannot alter the dirt.
Right.
Which naturally brings us to the next massive question. If the rights were already there and they already had boundaries, why did we build the House? Why go through the trouble and danger of creating a government at all?
We build it for one reason, according to Principle 3 of the Firewall Standard. Government exists only to secure and protect the pre-existing rights of the people.
Only.
Only. That is its sole object and its only legitimate end. It is an instrument of protection. It possesses no independent purpose, no independent will, and no claim to preservation apart from the people it was created to serve.
So the House is essentially a high-tech security system.
That's a good way to look at it.
But here's where the text introduces a massive distinction, one that I think explains almost all the political friction we experience today. It draws a hard line between protection and management.
Yes, that is a huge part of this.
And I feel like this is where we see the biggest diagnostic failures in the real world. How does the standard define the difference?
It defines protective action as responding to, preventing, or remedying an actual invasion of a right. It's the security system going off because someone is trying to break a window.
Yeah.
It's stopping the rain from ruining the inside of the house.
Okay, so what's management then?
Managerial action, on the other hand, is when the government directs peaceful conduct toward an outcome that the officials just happen to prefer, even when there is no demonstrated injury to anyone else's rights.
Let me use the house analogy again. Protection is the house keeping the burglars out and the rain off my head.
Right.
Management is the house waking up one morning and telling me what color I have to paint my living room walls, or what time I have to go to bed, or what kind of vegetables I have to grow in the garden, just because the house thinks it's a better outcome for the neighborhood.
That is exactly it. Indicators of managerial action include things like allocating private resources according to governmental preference, equalizing private conditions as an end in itself, or conditioning ordinary peaceful liberty on official approval.
So when they overstep that line,
When the government starts managing persons rather than protecting rights, it fundamentally changes its structural role. It stops being the servant protecting the land, and it attempts to become the master of the estate.
but to trigger that protective action, to justify the security system going off, there has to be an actual threat, right? The text calls this the injury connection.
Yes, Rule 3-point Lambda. This is a vital check on state power. For the government to use its coercive process to send a guy with a badge and a gun to your door, it must connect its action to an actual or legally cognizable imminent injury.
There has to be a victim, basically.
There must be a protected right, and that right must be demonstrably threatened by a specific action.
So a general claim from an agency saying, well, this new business model is risky, or this type of behavior is undesirable, or it's in the public interest for us to pause this activity, that's not enough to trigger the police power.
Under this standard, it is absolutely not enough. Speculative harm cannot be treated as though an injury has already been adjudicated.
They can't just guess.
Right? The government cannot just invoke society in the abstract or claim they are preventing some generalized future chaos. They have to state whose specific right is involved, what the specific imminent invasion is, and trace a specific delegation of power that authorizes a response to that specific injury.
And if they can't do all that,
If they can't do that, they are managing, not protecting.
I have to push back here on behalf of anyone listening who works in public policy or government administration, because I can hear them screaming at us right now.
I'm sure they are.
What if managing things is just vastly more efficient for society? What if the government stepping in, even without a specific localized injury, prevents a massive catastrophic mess down the road? Think about complex economic regulations or environmental planning.
Sure.
What about the general welfare? Doesn't the Constitution talk about promoting the general welfare and public safety? Don't we want the House to be proactive?
That is the most common, and frankly, the most persuasive argument for expanding government power. But this is exactly where the diagnostic standard is most rigorous and most unforgiving.
How so?
Rule 3.12 explicitly states that necessity, emergency, efficiency, or fear do not expand the end of government. Administrative convenience cannot substitute for a lawful delegation of power.
But what about the text? The words general welfare are right there in the Constitution.
The standard addresses that brilliantly. It argues that terms like general welfare, public safety, or happiness describe the results of a government that successfully protects individual rights.
Oh, they are the destination.
They are the destination. They are not blank check, independent grants of unlimited power to manage people's lives.
Wow. So general welfare is a destination, not the vehicle.
Exactly. You still have to show that the specific vehicle you are driving the delegated power is lawfully authorized to be on that road.
You can't just break the law to get there.
You cannot just point to the destination and say, I'm heading toward public safety, so I'm allowed to drive my tank over your front lawn to get there. An unlawful means remains unlawful, even if it's directed toward a legitimate end.
The ends don't justify the means.
Right. A good subjective motive on the part of a regulator does not cure a structural failure in their authority. You cannot protect rights by destroying the foundational mechanics of how rights are secured.
Okay, so we've established that the House is only there to protect the land, and it can't cross over into managing the people living there. But houses don't build themselves and they don't guard themselves.
Right.
The government is made of people. How does the government actually get the legal tools to do this protecting without becoming a threat itself?
It has to be handed those tools specifically, and that happens through the doctrine of delegation.
Right.
Principle 4 of the standard dictates that all governmental authority is derivative. The sovereign power resides originally in the people, the landowners. The people, acting as the principal, gives specific, limited, enumerated powers to the government, which acts merely as the agent.
Which introduces what the text calls the possession rule. You cannot delegate a power you don't possess.
This is a matter of basic logic. If you don't own a car, you cannot write a legal contract delegating the power to sell that car to a broker. You don't possess the title.
Of course not.
Similarly, an individual does not possess the inherent right to walk into their neighbor's house, audit their finances, and demand 30% of their income.
Right. If I did that, it would be extortion and theft.
Exactly. So the possession rule dictates that a majority of people cannot just vote to give the government a power that none of them possessed individually to begin with.
Wait, really? Just because a bunch of people vote for it doesn't make it a right?
No, collective action doesn't magically manufacture a new substantive right out of thin air. It just provides an organized way to exercise lawfully delegated authority that already existed in the hands of the individuals.
So, to prove that an agent actually has the authority they're claiming, the text demands what it calls the complete chain requirement.
Yes.
Walk us through this chain, because this seems to be the core diagnostic test that the whole X-ray machine runs on.
The chain must trace perfectly, step by step, from the origin of power to the execution of force. It goes like this: people, to law, to delegation, to jurisdiction, to due process, to judgment, to execution, and finally to accountability.
That is a lot of links.
And each link answers a separate, vital question. Did the people have the power? Did they put it into law? Did that law delegate the power to this specific branch?
Right. Does this specific branch have jurisdiction over this specific person?
Exactly. Did they follow due process? Did the neutral judge issue a judgment? Was it executed according to that judgment? And is the officer accountable for the execution?
And if they miss one?
If the government cannot trace its authority through every single one of those links, the action is presumed to be assumed power, not delegated authority.
And if a link is broken, let's say link number 2 is missing, the people never delegated it, but the agency is executing it anyway.
That triggers one of the most powerful concepts in the book, the first break rule, Rule 1.9.
The first break rule.
If there is a break early in the chain, say, the principal never possessed the power or the constitutional instrument didn't actually convey it, then every single downstream act rests on a defective foundation.
That makes sense.
And here's the kicker, the part that destroys most modern administrative arguments. No amount of later procedure or institutional acceptance or passage of time or aggressive enforcement can magically cure that original break.
Let me use an analogy here to see if I've got this. Think about a babysitter. You hire a babysitter to watch your kids on a Friday night.
Okay, perfect.
You are the principal, the babysitter is the agent. Your instructions: feed them pizza, put them to bed at 9 p.m. That's the delegated authority.
A perfect parallel.
So the babysitter can feed the kids. They can put them to bed. But the babysitter cannot suddenly decide while you're at the movies to sell your car or sign a new deed transferring your house to their name.
Why not?
Because I never delegated that power to them. The instrument of delegation, the sticky note on the fridge, didn't cover liquidating my assets.
Exactly. Now let's take your analogy and apply the first break rule. Let's say the babysitter does forge the title and sell your car.
Okay.
And let's say they fill out all the DMV paperwork perfectly. They get a notary, they pay the filing fees, they follow perfect administrative procedure in the act of selling it. Does that make the sale lawful?
No, because they never had the underlying authority to initiate the process in the first place. The first link was broken.
Exactly. A later valid step, filling out the paperwork correctly, cannot cure an earlier invalid step lacking the authority to sell.
Wow. Yeah.
Now, let's push the analogy further into Rule 4.23, institutional drift, and Rule 5.28, the no adverse possession rule.
Okay, let's say the babysitter doesn't sell the car, but they find the spare keys. And every weekend for 5 years while you're asleep, they sneak out and drive your car around town.
Okay, a joyride.
You just never noticed. Or maybe you noticed the gas was low, but you didn't object because you didn't want the hassle of finding a new babysitter. Does the babysitter suddenly own the legal title to the car just because they've been getting away with it for 5 years?
No. And this maps perfectly onto how government agencies operate. Long-standing governmental conduct cannot supply a missing constitutional grant.
So adverse possession doesn't work here.
No, government cannot acquire constitutional power through long, unauthorized possession the way a squatter might acquire land through adverse possession. The text says very clearly, institutional repetition cannot amend the Constitution. Duration does not convert assumed power into delegated authority.
So just because a federal agency has been regulating a specific industry for 50 years, if they can't show the original specific delegation of that power in the constitutional chain, it is still unlawful today.
Yes, the agent's practice cannot rewrite the principal's document. The babysitter's joyrides don't rewrite the sticky note on the fridge.
That is wild to think about.
Which ties directly into Rule 4.33, the badge, robe, license, and seal rule.
We touched on this earlier, right? The trappings of power.
Right. Symbols of office, a police badge, a judge's robe, a wax seal on a document, they identify the actor. They might authenticate that a document really came from a specific building. But they do not prove the existence of the underlying power. The law authorizes the office. The office does not authorize the law.
So a judge's black robe doesn't magically make a ruling lawful if the court fundamentally lacked jurisdiction over the subject matter.
Nope.
A police badge doesn't make an arrest lawful if there was no prior legal delegation and no due process. The symbol is just cloth and metal. It's the chain that matters. If the chain is broken, the badge is just a piece of jewelry.
Precisely. And this strict requirement for a complete chain and these absolute limits on delegation bring us to a concept that completely reframes the psychological relationship between the citizen and the state. And that is the concept of trust.
Yes, the public trust. So the government has been delegated these specific tools, these powers. They have the sticky note from the principal. But how do we make sure they don't use these tools to just enrich themselves or to protect their own jobs or to expand their own budgets?
By understanding that the Constitution is not just a political rule book, it is a strict legal trust document.
Right.
Principle 5 states that all public power is held in trust. It is not owned by the government or the department or the officer. They are merely trustees.
Meaning they have a fiduciary duty. They don't get to treat the trust property, which in this case is the coercive power of the state, as their own private plaything.
Exactly. Rule 5.9 is uncompromising on this. No public power can be used for private emolument or institutional self-preservation or professional monopoly.
Wait, really? Professional monopoly?
Oh, yeah. If a regulatory agency uses its power to create massive licensing barriers that don't actually protect the public, but solely financially benefit the regulators or the established corporations they are cozy with, they are engaged in self-dealing. They are embezzling the trust property.
And accountability is a huge part of this. You can't have a trust without a way to audit the trustee.
Absolutely.
The text says accountability isn't an optional feature of good government. It is inseparable from trustee status. An office that is categorically insulated from accountability has, by definition, assumed power. It's no longer acting as a trustee, it's acting as an owner.
Right. If you cannot be fired, if your budget cannot be touched, if your rules cannot be challenged in a neutral court, you are not an agent anymore. You're a sovereign.
Man, that's heavy.
And to prevent that abuse of trust, the standard introduces Principle 6, no will, only law. This explores the trichotomy of force, will, and judgment.
I really need you to break those three concepts down for us, because understanding how they separate is key to the whole diagnostic tool.
Will is the legislative capacity. It is the power of formulating general rules for the future. It's deciding what the law shall be.
Okay, will is the rulemaking.
Yes. Force is the executive capacity. It is the physical, compulsory execution of an existing law. It's the police power.
Got it. Force is the muscle.
And judgment is the judicial capacity. It is the quiet, impartial determination of what the existing law means when applied to specific past facts.
So will makes the rule, judgment interprets the rule, and force applies the rule.
Exactly. And the standard dictates that a governmental act is fundamentally unlawful when it substitutes personal preference, institutional policy, or raw will for controlling law.
Meaning they just do what they want.
Right. Discretion, substituted for law, converts delegated authority into arbitrary power. The executive cannot use force to impose its own will. It can only use force to execute the law.
But wait, I want to push back on this idea of institutional self-preservation being a breach of trust. Because we live in the real world. Isn't it just basic human nature and organizational psychology to want to protect your own institution? If an agency feels politically threatened, or if its budget is about to be slashed, it's going to look out for its own survival.
Of course they will.
And you could argue that without the institution surviving, the protective work can't get done. So is self-preservation a necessary part of the job?
You're hitting on the core vulnerability of every bureaucracy in history. But that is exactly the reasoning the text prohibits. Rule 3.14 explicitly states no circular governmental purpose.
No circular purpose, meaning a snake eating its own tail.
Yes, government cannot justify exercising power by invoking the need to preserve the exercise of that same power. Institutional survival is never an independent, lawful end of government.
Even if they do good work.
Even then, if an institution can only survive by operating outside its original constitutional grant, if it has to lie or expand its jurisdiction illegally just to secure its budget, it is acting unlawfully. The institution exists entirely to serve the trust. The trust does not exist to preserve the institution. The moment an agency acts to save itself at the expense of the citizen's rights, it has broken the trust.
That is a severe, unforgiving standard. It cuts right through the instinct to protect the bureaucracy. It basically says, if you have to break the law to save your agency deserves to die.
It does. It is uncompromising. And to ensure that impartial application of law over institutional will, the text emphasizes one of the oldest maxims in legal history. No one may be judged in his own cause. Rule 6.18.
Okay, let's unpack this one, because this seems to strike a fatal blow to the heart of the modern administrative state.
It absolutely does. The text applies this very broadly. A person or an institution acts as a judge in its own cause when it decides the legality of its own challenged act, the validity of its own rule, or the scope of its own jurisdiction.
Think about how modern agencies work, though.
Exactly. An agency writes a substantive rule. Then, its own investigators accuse a citizen of violating that rule. Then, the citizen is dragged into an administrative hearing where the judge is an employee of
that same agency.
Yeah.
Right. The agency is the legislature, the police, and the judge all rolled into one building.
And the standard says that body is inherently conflicted because the body has an institutional interest in preserving its authority and validating its own rule.
Obviously they do.
Its adjudication is just a validation of its own lawmaking act. You cannot combine the rulemaker, the accuser, and the final judge into one interested body.
Right.
That is the literal definition of substituting will for law.
Because human psychology dictates they will almost always rule in favor of their own power, which leads to something the text calls outcome-driven reasoning.
Yes, Rule 6.41. This is a brilliant diagnostic tool for reviewing judicial opinions or administrative rulings. The firewall demands that we test whether the actor selected the desired political or institutional outcome first and then constructed the legal explanation backward to fit it.
So they write the conclusion at the bottom of the page and then scrabble to find some case law to justify it. How do you spot that in the wild?
The indicators are very clear once you know to look for them. You spot it when a court changes the standard of review mid-analysis.
Oh, like shifting the goalposts.
Exactly. Or when they apply strict burdens of proof to the citizen, but incredibly lenient burdens to the government, or when they completely ignore controlling constitutional text without explanation.
Just skip right over it.
Yeah. Or, and this is the biggest red flag, when they rely on public policy or social necessity only after the actual legal authority fails.
Like it's a backed-up plan.
Right. When you see a court creating a bizarre one-time exception tailored perfectly to save a popular governmental program from being struck down, that is outcome-driven reasoning. That is arbitrary will, dressing itself up in a black robe and calling itself judgment.
And who carries the burden of proving this lawful authority? In this giant, complex system, if I challenge the government, who has to prove they are right?
The government. Always, always the government. Rule 1.10 and Rule 6.51. The citizen should never have to prove their innocence or prove their right to ordinary liberty.
So the state has to show its math.
Always. The government must demonstrate the governing law, the delegation, the jurisdiction, and the process. Unexplained power is presumed authority, not demonstrated authority. And under this standard, presumed authority is void.
Okay, let me synthesize where we are. We've mapped the land of pre-existing rights. We've built the house for the sole purpose of protection. We've handed the babysitter the specific instructions through delegation, and we've made sure they can't rewrite the instructions to buy themselves a new car or act as a judge in their own cause. The government is bounded by law, not will.
You've got it perfectly.
So what does it actually look like when they do lawfully exercise that power against a citizen, when the security system actually needs to go off?
They had to walk through the gate.
The gate. This is Section 5 of our deep dive, covering Principles 7 and 8, the 12-step gate of due process. And the very first thing the text says is that due process is structural. It is a condition precedent. What does that mean in plain English?
It means due process is not a review of a completed act. It's not the government kicking down your door, taking your property, freezing your bank account, and then holding a hearing a month later to see if it was a good idea.
Like, oops, sorry about that.
Right. Due process must happen before the deprivation. Rule 7.2 states it plainly. Forced preceding lawful process is not due process.
Process has to precede the penalty. You don't execute the sentence and then hold the trial.
Exactly. The text lays out 12 sequential conditions that must be satisfied. Think of them as 12 heavy deadbolts on a steel door. If you miss even one, the door stays locked. The government cannot cross the boundary.
Let's walk through this journey. Let's imagine a scenario. The government wants to shut down a citizen's business or arrest them or seize their property. What is the very first hurdle they must clear?
Step 1 is the injury or lawful predicate. We discussed this earlier. There must be an actual or imminent invasion of a protected right. Somebody must be demonstrably harmed.
So no predicate, no process.
Exactly. You can't start the machinery just because the government is curious or suspicious.
Okay, so let's say they have a predicate. A guy claims his car was stolen by his neighbor. What's step 2?
Step 2 is the sworn accusation or complaint. This is crucial. It must identify a real, legally accountable accuser, and it must state facts, not just conclusions.
Why is that distinction important? Facts versus conclusions.
Because Rule 7.11 says statements like the person is dangerous or the conduct is suspicious or the business is a nuisance. Those are conclusions. They are opinions.
Anyone can have an opinion.
Right. A fact is, I saw John Smith take the keys to the Honda Civic at 4:00 p.m. The oath binds a real person to those specific facts under penalty of perjury.
So it puts skin in the game.
Exactly. This prevents the government from starting the coercive machinery based on anonymous rumors or automated bureaucratic checkboxes or vague feelings of unease.
Okay, so we have a sworn fact from a real person. Can the police just run out and make the arrest now? Step 3.
Not yet. Step 3 is review by a neutral and detached magistrate. Rule 7.14. Human psychology tells us that an investigator or a prosecutor gets tunnel vision.
Oh, for sure.
They want to win. They want to close the case. So you need a neutral third party who is not part of the executive branch to look at the sworn oath. And this magistrate must have the actual legal authority to say no and reject the accusation if it's flawed.
They are a checkpoint. Step 4.
Step 4 is sufficient evidentiary cause. The magistrate has to look at the sworn facts and ensure they meet the specific legal threshold required for the action requested.
Like probable cause for an arrest.
Yes, the facts have to carry the weight of the request.
Step 5.
Step 5 is the lawful charge issued upon that cause. The charge must connect the specific facts to a specific antecedent law.
Antecedent meaning it existed before the event.
Yes. You cannot be charged for conduct that wasn't legally prohibited before you did it. There is no making up the rules after the game has started. If the neighbor took the car, there must be a law against theft on the books before he took it.
Okay, so the guy is charged. He's facing the power of the state. Step 6.
Step 6 is notice and a public hearing before a lawful tribunal and court of record. You have to know exactly what you are accused of, and you must have a meaningful opportunity to contest it.
Meaningful is key here, I assume.
Very much so. It means having access to the evidence, the ability to call witnesses, and the time to prepare. Notice delivered the night before a hearing is not notice. A hearing held in secret is not a lawful hearing.
Step 7.
Step 7 is an impartial tribunal and a jury where required. The adjudicator, the judge, must have no financial, institutional, or prior personal interest in the case. They cannot be paid from the fines they collect.
Well, let's pause on the jury part, because Principle 8 focuses heavily on this. The text seems to elevate the jury to an almost sacred status. It says juries aren't just administrative tools to help judges figure out facts.
Far from it. The jury is the ultimate structural check on state power. The text argues that the jury interposes the judgment of the local community between the individual and the coercive power of the state.
It's a share in the power.
It's a direct share in judgment retained by the people themselves.
It's the homeowner sitting in the living room keeping an eye on the babysitter.
That is exactly what it is. Grand juries check abusive accusations at the front door. Paid juries check abusive convictions at the back door.
So a judge can't just bypass them?
You cannot bypass the jury just because a judge or an administrative agency finds it more efficient or predictable to rule without them. Efficiency does not trump the people's right to check the state.
Okay, we're in the trial. Step 8.
Step 8 is the burden of proof on the accuser. The government must prove every essential element of the charge. You, as the citizen, are not required to disprove an unsupported allegation.
So silence isn't guilt.
Silence does not equal guilt. Refusal to cooperate with an unlawful investigation is not evidence of a crime. The state brought the charge. The state carries the weight. Step 9 is judgment according to established law and proven facts. The tribunal cannot base its judgment on secret evidence, or the judge's policy preferences or assumptions about what probably happened.
It has to be on the record.
Yes. The judgment must flow inevitably from what was actually legally proved on the public record.
Step 10.
Step 10 is no punishment or deprivation without lawful judgment. This is massive. You cannot treat an arrest or an indictment or an administrative suspension notice as the final legal equivalent of a judgment.
So they can't say, well, you've been indicted, so we're going to seize all your assets and sell them before the trial.
Exactly. Punishment must follow final adjudication, never precede it. The process is the barrier preventing the punishment.
Step 11.
Step 11 involves criminal safeguards where applicable. Rule 7.65. If the proceeding threatens liberty, property, or reputation in a fundamentally punitive way, all the cumulative safeguards of criminal law apply.
Like the right to an attorney.
Right. The right to counsel, the right to confront your accuser, the requirement of proof beyond a reasonable doubt.
But don't agencies try to get around this by just calling things civil penalties?
All the time. And the standard explicitly blocks that. The government cannot just slap a civil or administrative label on a proceeding to avoid these strict safeguards if the substance of what they're doing is actually punitive.
So you can't just rebrand it?
No, you can't call a prison a mandatory wellness retreat to avoid the right to a trial.
And finally, the last lock on the door. Step 12.
Step 12 is force or execution, only after these are satisfied. Due process is the completed barrier. Only when all 11 previous steps are successfully demonstrated can the government lawfully execute its judgment and cross the boundary into your property or liberty.
Okay, I have to ask about a massive loophole that governments use all the time. What does this standard say about the concept of retroactive validation? Because I see this happen in the news.
Oh, it's very common.
Right. A government actor, maybe a regulator or a police officer, jumps the gun. They seize property or they shut down a business without a warrant. And then, a month later, they go to court and get a judge to sign an order making it look official. They backdate the authority.
Rule 7.84 explicitly prohibits retroactive validation. It is structurally void. A later hearing or a signed order cannot magically cure a lack of neutral review or a missing sworn accusation at the exact moment the force was used.
So the timeline is sacred.
It has to be.
Yeah.
The legality of the original act must be judged by the law and facts existing at the exact millisecond the act occurred.
Wow, millisecond.
Yes. If the condition precedent of the warrant, the oath was missing at that moment, the act was lawless force, and all the downstream acts that rely on it are infected. You cannot build a lawful house on a foundation of lawless force.
But wait, I have to push back again. What about emergencies? Surely the text isn't a suicide pact.
Right. People always ask this.
If there is an active threat, a house is on fire, there's an active shooter in a building, and immediate physical danger to a child. The government can't sit around waiting to check off a 12-step process. Can't they skip steps if there's an immediate catastrophic threat?
This is a critical distinction, and it's addressed in Rule 7.70. An emergency does not eliminate the sequence of due process. It is merely a narrow, strictly defined timing exception.
A timing exception? How does that work?
The emergency authority to act without a prior warrant must still be delegated by law in advance. The officer kicking down the door to save the child must still be able to identify the specific right threatened and the actual objective facts establishing immediate danger.
So they can act in the moment?
They can act temporarily using force, yes. But that temporary action must be followed immediately by prompt neutral review and the full post-action process.
So the bill still comes due.
Exactly.
Did it-
Emergency doesn't create a new, ungranted magical power. It merely alters the timing of the required process. And even then, it only alters it to the extent the pre-existing law explicitly allows.
You can't just declare a perpetual emergency.
You cannot just declare a public health emergency or an economic emergency to bypass the Constitution permanently and rule by decree. Rule 3.12 stands firm. Necessity does not expand the end of government.
And this brings us to one of the final concepts in the book, which I think is a brilliant way to wrap up the mechanics. Rule 7.99 introduces a concept called structural symmetry. I love the sound of that phrase. What does it mean?
Structural symmetry means the government cannot demand strict adherence to legal thresholds from citizens while excusing itself from those exact same conditions.
Give me an example.
The government cannot require you, the citizen, to prove a concrete, specific injury to file a lawsuit in court, but then turn around and allow its own agencies to regulate your life based on abstract, generalized, speculative concerns.
Oh, that makes so much sense.
The government cannot demand that you meet strict 30-day filing deadlines to appeal a tax ruling, but excuse its own years-long delays because of administrative burden or understaffing.
That is incredibly powerful. It stops the House from playing by a different, easier set of rules than the landowners.
Precisely. The due process structure must constrain the government, at least as seriously as it constrains the people.
No double standard.
If the government wants to cross the rights boundary, if it wants to cross what is essentially the theft line, it must unlock every single lock on the due process gate on time with the proper authority. There are no shortcuts. There are no VIP passes for the state.
Okay, let's take a deep breath and synthesize the journey we've just been on, because this has been a dense but absolutely incredible deep dive into the underlying architecture of power.
It really is a lot to take in.
We started by looking at the X-ray and realizing that we can't just judge government by its symbols or its good intentions. We learned that the sequence of freedom is strict law, and rights predate the government. They are the land existing long before the house was built.
Beautifully put.
We saw, through the pocket tests, that true rights don't compel the labor of others. We learned that the government's only legitimate job is protection acting as a security system for those pre-existing boundaries. It is not there to manage peaceful conduct, dictate outcomes, or redesign the landscape.
Right, it's not a manager.
We traced the rigorous rules of delegation. The babysitter only possesses the specific tools written on the sticky note, and the government must prove a complete, unbroken chain of authority for every single act. We explored the public trust, the realization that public officers are merely trustees who cannot use their power for private gain or to ensure the survival of their own bureaucracies.
Law must control, not arbitrary will.
Exactly. And finally, we walked through the 12-step gate of due process. We saw that process must precede punishment, that you cannot be a judge in your own cause, and that the government must satisfy every single condition precedent before it can lawfully cross the boundary into your life, liberty, or property.
It is a diagnostic standard that, if actually applied, replaces the endless, toxic argument from political preference with rigorous demonstration from constitutional law. It forces the state to show its math.
Which leaves me with a final provocative thought for you, the listener, to mull over as you go about your week. It builds on Principle 5, the idea that the Constitution is a trust. In trust law, there is the trustee, which is the government, the trust property, which is public power, and the beneficiaries and settlers, which is us, the people.
Right.
If the Constitution is a trust document and the government is merely the trustee, what happens to the psychology of a nation when the beneficiaries completely forget their status?
That is the ultimate vulnerability of any republic.
Think about it. When citizens constantly beg the government for permission to exercise their pre-political rights, when we assume the government has unlimited power just because an official is wearing a badge or a document has a gold seal, are we functionally living as subservient tenants in a house we actually own?
Are we asking the babysitter for permission to drive our own car?
Exactly. Have we surrendered the title to the land simply because we forgot we held it?
The standard reminds us, forcefully, that we are the principal. They are the agent. And an agent only has the power you demand they prove.
So, the next time you encounter governmental authority, whether it's a local zoning board telling you what you can build, a tax notice in the mail, a police officer on the street, or a sweeping new federal regulation on the evening news, don't just look at the uniform, don't just read the official letterhead. Remember the X-ray machine.
Look past the surface.
Look past the surface, look at the mechanics of the power, and ask the diagnostic question, by what lawful authority may this act be done? Because enforcement proves power, but it does not prove law. Thank you for joining us on this deep dive. Keep asking the hard questions, keep checking the locks on the gate, and we'll see you next time.